Today, in the media conference with Lal Goel, which is brought to you by V4 News, Global TV, V4 Stream, Malnadu TV, News Gaon Se, Samvad Sarokar News, Organ Donation India Foundation and Gyan, our endeavor is to enlighten you about the current topics. And the topic which is there today is a very burning topic because we are discussing about the Forest Rights Act, BANE or BOON. But before I will go for the topic, I would like to inform you that today India is celebrating Kisan Divas or the Farmers' Day. To those who work in acres, not in hours, we thank them from our heart. The National Farmers' Day in India is also known as Kisan Divas. Farmers' Day is celebrated every year on 23rd December on the birthday of the 5th Prime Minister of India, Shri Chaudhry Charan Singh. He was also a farmer who introduced many policies to improve the lives of the Indian farmers. This day is celebrated by organizing various programs, debates, seminars, quiz, competitions, discussions, workshops, exhibitions, essay writings, competitions, and functions. Kisan Divas is observed as a day to celebrate the farmers who form the backbone of our agriculturally backed country. This year, farmers are doing agitation against the new 3 Farm Acts. We wish everyone a very happy Farmers' Day and sincerely hope that the protest end as early as possible. Now coming to the topic, that is the Forest Rights Acts, BANE or BOON. Deep in the forest, I stroll to hear the wisdom of my soul. The death of the forest is the end of our life. The scheduled tribes and other traditional forest dwellers Recognition of Forest Rights Act 2006 is a key piece of forest legislation passed in India on 18th December 2006. It has also been called the Forest Rights Act, the Tribal Rights Act, the Tribal Bill, and the Tribal Land Act. The law concerns the rights of forest-dwelling communities to land and other resources denied to them over decades as a result of the continuance of colonial forest laws in India. In the colonial era, the British diverted abundant forest wealth of the nation to meet their economic needs. While procedure for settlement of rights was provided under statute such as the Indian Forest Act 1927, these were hardly followed. As a result, tribal and forest-dwelling communities who had been living within the forest in harmony with the environment and the ecosystem continued to live inside the forests in continual insecurity, a situation which continued even after independence as they were marginalized. The symbiotic relationship between forests and forest-dwelling communities found recognition in the National Forest Policy 1988. The policy called for the need to associate tribal people in the protection, regeneration, and development of forests. The Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Rights Act 2006 was enacted to protect the marginalized socio-economic class of citizens and balance the right to environment with their right to life and livelihood. An act to recognize and vest the forest rights and occupation in forest land in forest-dwelling scheduled tribes and other traditional forest dwellers who have been residing in such forests for generations, but whose rights could not be recorded, to provide for a framework for recording the forest rights so vested and the nature of evidence required for such recognition and vesting in respect of forest land. Supporters of the Act claim that it will redress the historical injustice committed against forest dwellers while including provisions for making conservation more effective and more transparent. The demand for the law has seen massive national demonstrations involving hundreds of thousands of people. However, the law has also been the subject of considerable controversy. Opponents of the law claim it will lead to massive forest destruction and should be repealed. A little over 1 year after it was passed, the act was notified into force on 31st December 2007. On 1st January 2008, this was followed by the notification of the rules framed by the Ministry of Tribal Affairs to supplement the procedural aspects of the act. The act can be summarized as title rights, that is ownership to land that is being farmed by tribals or forest dwellers as on 13th December 2005. Subject to a maximum of 4 hectares, ownership is only for land that is actually being cultivated by the concerned family as on that date, meaning that no new lands are granted. Use rights to minor forest produce, which also including ownership to grazing areas, to pastoralized routes, etc. Relief and development rights to rehabilitation in case of illegal eviction or forced displacement, and to basic amenities subject to restrictions for forest protection. Forest management rights to protect forests and wildlife. A great deal of debate is fueled by misunderstandings of the purpose of the act. The most common is that the purpose of the law is to distribute forest land to forest dwellers or tribes, often claimed to be at the rate of 4 hectares per family. The act is intended to recognize lands that are already under cultivation as on 13th December 2005, not to grant title to any new lands. There have been numerous complaints regarding the manner in which the act has been implemented after its notification. For instance, in September 2010, the Council for Social Development, a New Delhi-based think tank, released a summary report on implementation of the Forest Rights Act, which stated that all the key features of this legislation have been undermined by a combination of apathy and sabotage during the process of implementation. In the current situation, the rights of the majority of tribals and other tribal forest dwellers are being denied, and the purpose of the legislation is being defeated. Unless immediate remedial measures are taken instead of undoing the historical injustice to tribal and other traditional forest dwellers, the act will have the opposite outcome of making them even more vulnerable to eviction and denial of their customary access to forests. Both the central and the state governments have actively pursued policies that are direct violation of the spirit and letter of the act. Order of the Supreme Court of India in the matter of Wildlife First and Others versus Ministry of Forest and Environment and Others, dated 13th February 2019, regarding claims under Forest Rights Act 2006 India. Affidavits were filed by the states giving information about the number of claims under FRA by STs and OTFDs. The Supreme Court has ordered the forced eviction of more than 10 lakhs tribal and other forest dwelling households from the forest lands across 16 states after the government failed to defend a law protecting their rights. This order invited challenges from various quarters, as in many cases request was cancelled on non-availability of documents by district level committee under the act. On February 28th, 2019, the court stayed its order, though it said the mighty and the undeserving who have encroached on forest land would be shown no mercy. It has decided to examine whether due process was followed by the Gram Sabhas and the states under the Forest Rights Act before the claims were rejected. And to discuss today's topic, that is Forest Rights Act, BANE or BOON, We have a very elite, experienced, learned panel with us. And I would like to invite my first guest, and he is Mr. Bhupati Prasad Pandey, IAS. Mr. Pandey is the former Additional Chief Secretary, Government of Maharashtra. He is of 1976 batch. He is an alumni of Patna University. Before joining IAS, he was an executive officer in Bokaro Steel Limited. Mr. Pandey carries a vast experience in various infrastructure sectors, ports, power, environment, forest, and most importantly, employment and self-employment. He implemented a self-employment policy in Maharashtra, which was applauded in the state legislature and gave a platform to youth and women to work for financial freedom. He has been quite keen to work on the strength of his experience to channeling the energy of youth, migrant labor, and women folk. Welcome, Mr. Bhupati Prasad Pandey on our show. Mr. Pandey, you have worked in the forest mantralaya or secretariat, and you have also worked in the environment. So you know the ins and outs about the forest and the environment. And you are quite familiar with this Forest Rights Act 2006. So we would like to know from you, this Forest Rights Act is a boon or a bane? Mr. Bhupati Prasad Pandey, please.
Thank you, Mr. Goel, and welcome to this panel, fellow panelists and friends. Before we embark on the discussion, I would like to just highlight the utility and the need for forests. Our need for forest arises on account of primarily three reasons: for carbon sink and environmental maintenance, as Mr. Goel has also pointed out; for water, which includes enhancing groundwater recharge, as well as maintenance of surface and subsurface flows in rivers and springs; and for the livelihood and sustenance of millions who are dependent on forests, the subject matter of today's discussion. The Forest Act 2006 is an important piece of legislation which sought to democratize forest governance in India by securing rights of forest dwellers and Adivasis. It also empowered Gram Sabhas to govern community forest resources and rights. The Forest Acts of 1865 and later of 1927 sought to consolidate the law relating to forest and forest produce. Even the Forest Conservation Act of 1980 aimed at providing higher level of protection to forests and regulate the diversion of forest land to non-forestry purposes. It was left for the Forest Rights Act 2006 to do away with the injustice suffered by the communities and inhabitants who depended on forests for their bona fide livelihood requirements. The Forest Rights Act has a historical importance and is an act of high potential for reasons. Number one, for the first time, the forest dwelling scheduled tribes and other traditional forest dwellers' right on forest and its produce got recognized. Two, a democratic process for conservation, maintenance, and distribution of forest produce was recognized, and Gram Sabhas were empowered for that purpose. Third, the encroachers for the first time came to be considered and recognized as important agents of conservation and management of forests and wildlife. Four, the need of fixing of boundaries of forests after rehabilitation of encroachers in the scheduled area and reduce the scope for man-animal conflict. Further, sustainable development goals were for the first time attempted to be met. And finally, gender equity was emphasized for the first time. Forest rights for the first time were decided to be granted in the name of both the spouses or in the name of single household head, irrespective of gender. Households headed by women only were recognized to be granted forest uh, rights in the designated areas. However, uh, despite these distinctive features, the Act had its own share of weaknesses, of which two most important weaknesses were number one, the nodal agency for the implementation of the Act is the Tribal Affairs Ministry required to operate in a democratic setup for recognition of forest rights. The great faith in democratic wisdom over judicious implementation has resulted in a slipshod achievement of objectives. Thus, in one district, the village boundaries were merged, shifted at the local level to accommodate beneficiaries despite existing land records and satellite imageries showing non-existence of forests in the relevant areas. Two, the provision, for example, that a certificate from an aged person of the village that the applicant has been a forest dweller for the last 75 years would be accepted as conclusive proof of such dwelling, even in the face of other disputed proofs and records, has created problems. In Maharashtra, in a large number of cases, such octogenarian certificates have been accepted to grant forest rights, even on the face of satellite imagery disputing such certificates. Not only that, in one district, even on the face of admissions made by the applicants that they have not been residents in the forest area for the required 75 years, community forest rights have been granted to them. Extraneous considerations, other than factual and technical ones, appear to have prevailed upon the committees granting forest rights in numerous cases. Nearly 1.5 decades of the Act being in force has given us an insight to the challenges and perhaps the way forward. Since the time is short, I would only refer to the issues. What is required is a demarcation of exact area where Forest Rights Act has to be implemented, listing out all inhabitations having a forest interface, whether such inhabitations are recorded or unrecorded. Two, a cutoff date or time limit for submission of claims of individuals and or community rights has to be declared, and maps etc. have to be made available at the local decision making levels. Three, training and capacity building for local level functionaries and claimant beneficiaries has to be continuous and continued on a regular scale. The emphasis has been more on individual claims, whereas emphasis on truly admissible community rights and community resource rights to the genuine and eligible communities is called for. Its area has to be demarcated by the managing committees elected and trained for that purpose. You'll be surprised to know that till 2018, only 1.6% of 2.9 million claims in the country had been approved till that year. And finally, Forest Rights Act should be dealt with in conjunction with the Panchayat Extension to Scheduled Areas Act 1996 in the scheduled areas. Since we are short of time and I don't want to pinch upon my other panelists' time, I would rather leave it at this and come back to you later.
And
Thank you very much, Mr. Goel, and let us have a worthy discussion on this subject
thank
to
you.
find solutions.
Thank you very much, Mr. Pandey, for giving your views and its opening remarks. And Mr. Pandey mentioned very clearly about the benefits as well as the weaknesses of the Act, the 2000 Act, the Forest Rights Act. And he also gave his suggestions which how the things can be improved and which he has already explained. And as he has mentioned the paucity of the time, I will not going to summarize everything, but I will only say the act which was formed in 2006 are having lots of things which were supposed to be implemented properly, but they were not implemented. As we rightly mentioned, that only 1.6% claims were settled out of 2.9 million claims. It is very, very shocking, and it is not a healthy thing for the our country, which is in the 21st century. Thank you very much, Mr. Pandey, for giving your opening remarks and your views. Now I would like to invite my next guest, and he is Mr. Dr. Dhirendra Kumar Srivastav, IFS. Dr. Srivastav is the former chairman, Jharkhand Public Service Commission, Government of Jharkhand. Dr. Srivastav is an IFS officer of 1979 batch of Jharkhand. Earlier, it was Bihar cadre from that. And MSc in botany and PhD in floristics and ethnobotany of Santhal Paraganas. He served in tribal-dominated forest districts of the newly formed state of Jharkhand. He believes in participatory forest resource management and remained actively associated with JFM. Dr. Srivastav has steered working of watershed management, SHG-based rural development during his postings in Rural Development Department, Government of Jharkhand. Dr. Srivastav taught botany before joining the Forest Services and still finds time to interact on subjects like forest ecosystem, including people living in and around forests. Welcome, Dr. Srivastav, on our show. Dr. Srivastav, you have heard what Mr. Pandey has mentioned, and which you have already, being an IFS officer, you know ins and outs of the Forest Rights Act. Now, we would like to know from you, the Forest Rights Act, BANE or BOON? Dr. Srivastav, please unmute yourself. Please unmute. Yes.
Good morning, Mr. Goel, for introducing me, and morning to my fellow colleagues on the panel. The subject is really very interesting, but we are at a juncture wherein the very question, which may sound really critical when we are raising issues like whether it is BANE or BOON. Let me say a word on the forestry acts that have prevailed so far. Democratization, which is the cornerstone in the FRA system of administration and implementation, has been one of the important ingredients in the Forestry Act's implementation, be it in Indian Forest Act, through awarding forest rights to the forest dwellers, be it the Forest Wildlife Protection Acts, or similar acts which were implemented over the period of time. And these feelings, these were already realized at the ministry level also and the field officers also. There is something missing, that we are probably missing the connect between the people who are living in and around the forest area and the forestry governance, the forest officials or forest managers, basically. And the turning point came in the 1990 by the issuance of circular by the Ministry of Environment and Forest, wherein the participatory forestry management was made a very much in thing, that the people living in around the forest area should be a participant in the forest management system. But we must confess that simply issuance of the circular didn't serve the purpose. It has to be driven to the logical conclusion. Somehow, because of so many acts and rules, not only by the forestry department, but other departments also, which started the the kind of they started running the contrary to the purposes and cutting each other motives, or in the simply in the implementation itself.
Dr. Srivastav, some disturbance is coming because it's a live telecast. Can you just see the sound is coming, disturbing sound? So our viewers will be not happy. Please, thank you.
I'm sorry, I'll try.
Sorry, thank you. Yeah.
So by simply issuance of circulars or acts and rules, that's what I feel, is not adequate. Instead, the implementation regime, the entire implementation framework, the operational framework is to be looked into in the holistic regime of the thing. By issuing the circulars in 1990, the at the country level in different states, a concept of village level committee named called Joint Forest Management Committee were formed, and to assist them, one of the cutting edge officers of the forest guard was made just to assist them so that they can appreciate various nuances of the acts that are prevailing in the area. But as I said, it couldn't see through much success except certain areas, certain states, certain districts. Meanwhile, some other acts also came into being, like Panchayati Raj extension to the scheduled areas by the Panchayati Raj department. Then Forest Right Act came for the entire scheduled area affecting 6 schedules. But the provision of these things, these two acts also were not homogeneously synchronized so that the implementation can effectively be can reach to the ground level. At the same time, the forest managers felt that probably they were not an active partners in the implementation module except at the SLDC level. So somehow the act should have been in consultation with the forestry, not the I don't say the department, but the forestry circulars, the forestry working plans, the forestry documents. It must have been seen, but it is not adequately reflected at the implementation level. With the joint forest management is always has always kept in view. Like for instance, there are certain bottlenecks which have come. Whereas the in the PESA, it says that the Gram Panchayat in the consultation level will prevail. But the Forest Site Act, it empowers Gram Sabha for many or so many other provisions, decisions. Similarly, the other bottlenecks in the when subjectivity creeps in, like declaration of critical wildlife habitat, on the issue of coexistence. I propose in this scenario, not taking much time because my earlier speaker has already spoken on the Forest Right Acts, its pro and the other aspects of it, that the JFM Joint Forest Management Committee, which has already run for the more than 20 plus years in the village forest village regime, they should also be made either part of it or their members should be part of the FRA implementation committee, which is called Forest Right Committee at the Gram Sabha level. This is not necessary that you convert the JFM committees to the Forest Right committees. because it's the village level leadership issues, that if somebody has run for the 20 years as the secretary or the chairman of the Gram JFM committees, if you suddenly take away his rights or authority or his understanding or command over the Gram Sabha, this may create some kind of uneasy discomfort in the village system. So what will happen ultimately? The entire spirit of the forest rights might get defeated. Next issue I'd like to mention is that we have been over the years, including civil society and even various monitoring bodies, have focused, concentrated more on the generation of the claims, number of claims. Instead, I'll suggest it should be the generation of quality claims so that the percentage of success is achieved better. Why the quality suffers? Because probably at the grassroots level, at the Gram Sabha level, either or even in the other SDLC or other level, we are not able to understand the legal languages that have been given, included either in the act or the rules or the directives. The operational mechanism is not very clearly set out, that how will actually be the identification of correct beneficiary will take place. Many things have been delegated to the forest rights committee at the Gram Sabha level, but they are not adequately empowered, as my experience goes, to appreciate, to understand, to take a decision technically that, well, the beneficiary deserves to be, given the claim, allowed the claim. Third, a very practical issue is we have given this responsibility to the Department of Welfare. I know of the Jharkhand state, the forest department, who are the cutting edge of the field formation, who are involved in identification, interacting with the Gram Sabha, picking up the beneficiaries. The capacity of these people are not adequate, including the knowledge on the law front, even the technical expertise they don't possess. And for this, they need the support of somebody at the district level or the divisional level. The number of, next is the strength of their staff. That is the people who are going to attend the meeting, their forest range officers or the assistant conservator of forest or the foresters. Their number is not adequate. Even the appointments have not come through over the long period of time. So if you don't have many people, adequate desired number of people who can really facilitate the selection and the attendance of the meeting, so the correct situation may not actually be reflected in the SDLC or DLCC. It will only remain in the papers if we start monitoring or implementing mechanism that, well, you come out with the report within 1 month that 80% of the area is covered under the FRA, and your forest site tax habitation, you have to visit and give me the report. It's not possible. That is to say, what I meant is, on the practical level, everybody has to ensure that the people are in position to, people are able to understand, they have to be empowered. People means the forest or the welfare department official and staff, and also the members of the Gram Sabha who are given the responsibility to take decision on selection of beneficiary or the area which we are talking about to be taken in the for the Forest Rights Act. Then there are certain issues which already have been discussed by Dr. Pandey before me, that more focus is to be given on the identification of area, whether it should pass on to the forest right holder correctly, identified beneficiary or not. If the land is correctly identified to have been to become eligible for the transfer to the forest right holder, then it's fine. If it is not eligible and transferred, then the Damocles sword will fall on somebody's head. So the identification of the beneficiary as well as the land in question, forest land in question, is very, very important. And for this, all kinds of capacity building approach and very intensive monitoring requires to be done, so that the rationalization of these things uh, in the process takes place. It's not that only because somebody says you have to finish the job within given 1 month of time, which is maybe inadequate. Maybe adequate is, if once it is adequate, it's fine. If it's not adequate, we should wait. We should try to strengthen them. We should try to empower them. I mean, the system should be such flexible. And lastly, before my time is out, for any such kind of scheme which is loaded with so much democratic authority, there must be an adequate uh, this a vehicle for this purpose should be created at the state level, at the district level, wherein the experts from different departments are drawn and their suggestions should be recorded, taken, and all the level. We have the case in question like NRLM, its predecessor SGSY, its predecessor another scheme. Now NRLM, the livelihood mission, is succeeding very well, doing very well in different states. I know for my state, we should have a special purpose vehicle for this kind of thing also, if we really need our this Forest Rights Act implementation to be real good thing in the right and spirit. Thank you very much.
Thank you very much, Dr. Srivastav. And Dr. Srivastav also said almost the same thing Dr. Mr. Pandey has mentioned. He says the law which was enacted was good in one way, but the implementation part was faulty. And for this, the main reason is that the Gram Sabha members or the forest people or those who are the welfare department people, they are not adequately trained legally also as well as the practically, so that they cannot get the things done what the law requires. And that's why the time taken, because the time frame is if 1 month, it's not possible to implement the law in 1 month's time because they are not adequately trained. And because the language is such in legal language which the local people were not understanding clearly, and that's why the lots of confusion and the law could not be implemented, which this should have been done. And for that, his suggestion is that first we should train them adequately, give them the proper training, give them, if for this he even says that a special purpose vehicle to be set up in which those who are known or those who have experience or those who have knowledge, such type of officer or employees to be drawn in that SL, special purpose SPV, which can do the implementation part of this act. Otherwise, this act is not giving the benefit or reaping the benefit which was made for that. Thank you very much, Dr. Srivastava, for giving your views. Now I would like to move to our next guest, and he is Dr. Arvind Kumar Jha, IFS. Dr. Arvind Kumar Jha, IFS, is the former PCCF and DG Social Forestry, Government of Maharashtra. Dr. Jha is of Indian Forest Service 1980 batch, Maharashtra cadre. Dr. Jha did MSc Physics, MS Sociology, LLB, and PhD in Social Science. He published 43 articles and 2 books. Dr. Jha received National E-Governance Award from Government of India for use of geoinformatic in implementation of Forest Rights Acts in Maharashtra and Brandeis Award for writing on forestry. Currently a student of conservation and legal issues related to forestry, wildlife, biodiversity and tribal development. He is also a member of Bar Council of Maharashtra and Goa. Welcome, Dr. Arvind Kumar Jha on our show. Dr. Jha, you have already heard what Mr. Pandey has mentioned and what Dr. Srivastav has mentioned. And both said that although the act was enacted in 2006, but till now, the benefits of the acts have not been passed for which the act was framed. And that's why until unless there is we will not do many changes, radical changes, which are required with a holistic approach. The beneficiaries are not getting the benefit which they are entitled for. Now, we would like to know from you the Forest Rights Act, BANE or BOON. Dr. Arvind Kumar Jha, please.
Thank you, Dr. Goel, and thanks so much, all my fellow speakers. I'll come to the Forest Rights Act's basics. I mean, one way is to consider it in a general kind of a scenario, but the Act doesn't only speak of the recognition of forest rights, but it also talks of sustainability of forests, empowering people, especially the forest dwelling scheduled tribes and other traditional forest dwellers, empowering them to be able to manage forests, to protect forests, and work in tandem with the forest department's hands, and of policies. Now, as was rightly pointed out, the act was started, publicized as an act which was supposed to give land to people, pattas to people, to quote the specific term normally that is being used. But the fact remains that the first step of saying that it is to give pattas is wrong. And it created a lot of confusion all over. This act does not provide any kind of ownership rights on land. It provides ownership of right. The forest right is owned by the person to be exercised on the land on which that forest right is claimed, if the claim is found to be correct. So the basic sentence with which I'll start is that the forest rights will exist only so long as forests will exist. That is the fundamental thing that must have gone into the background thinking so far as this act is concerned. Then there is a lot of specificity about the target group and the forest rights in this act. First is that it is only supposed to be for the forest dwelling scheduled tribes and other traditional forest dwellers. And these two categories of people have been very nicely and correctly defined in the act and rules. There is a feeling all over that it is supposed to be for all the people, all the forest dwellers, all the scheduled tribes. No. They have to be forest dwellers and they have to be dependent on the forest for their livelihood. Then the target resources on which forest rights can be recognized, they are also very clearly specified under the Act. And there are conditions laid down for each type of forest right. Those conditions have to be fulfilled in case we have to see and decide in favor of a person getting a forest right under this Act, recognized in his favor. And the third most important point is that in each case of individual forest rights or community forest rights, the title on the forest right has to specify nature as well as extent of the forest rights. This is very important because the nature determines the connection between the person who has got the right and the resource on which the right is given. And the extent says how much, on what area. That is very essential if we think in terms of planning for ensuring the sustainability of the forest rights that are being recognized today. Now, nature as well extent, they have to be specified in each case. Now, the aspect of BOON or BANE. You see, the Act came with a very good purpose. It wanted to so-called historical injustice to be removed. But we also have to see that during implementation, the historical injustice should not happen to the forest resources, on which not only the forest dwellers depend, but you and I, everyone on this earth, we depend for our lives. I'll quote some very specific examples. You see, the target population for the Act is FDSTs, I'll use the acronym, and the OTFDs, Forest Dwelling Scheduled Tribes and other traditional forest dwellers. But these, the definition got changed in a rule by amendment in 2012 by the Ministry of Tribal Affairs. And the term which was used was sustenance needs. It was replaced by livelihood needs. So you can see the difference. In the beginning, it was supposed to cater to the needs of the people who sustain on the forests. And now anybody who has some connect with the forest as a livelihood need, he also gets covered, which means the target group got increased manifold in 2012 because of this kind of a new definition. On the other side of it, I'll say that the real beneficiaries intended to be catered to in terms of providing benefits to them, that got marginalized during the process by this modification. And the relatively rich, the relatively powerful, the rural elite, they started coming into fray. Next point I'll take, the forest right committees and Gram Sabha level, no government servants are involved as member. So it's purely democratic, people-oriented at the village level when it comes to examining the claim, scrutinizing the claim. The Gram Sabhas did not sit with quorum. Initially, it was 2/3 quorum. Now it is half. Even half quorum is not possible in Gram Sabhas in most of the times, and which raises a question mark on the quality of scrutiny that is being done at the village level. Participation in the process of determination of forest rights at various levels also included the participation of people, 3 representatives who were not officials. But when you study the case papers, you will find that in most of the cases, just the committees members who are the government servants, they are attending the meetings. And that is creating a lot of problem. The forest department officer who is actually having a lot of knowledge about the forest, he is just a member of the committee. The chairman is the revenue officer and the member secretary is the tribal department officer. This is the structure of committee at the district level and also at the subdivision level. Now, as per the Act and rules, the FDSTs and OTFD communities had to be empowered for protection of forests and their cultural traditions. But the fact remains that no action has been taken in this regard till now. So we are, in a way, we are just saying that these are your rights, but where these rights will be exercised, that particular resource, we are not thinking of developing at all. And again, the responsibility part of the right holders is not being addressed at all. We are still, more than 10 years of implementation has gone. We are still concentrating on giving as many rights as possible, as many cases clearance as possible. And as of now, as per August data, 42.8 lakhs cases are there. Out of that, 19.9, almost 20 lakh cases have been decided in favor of the claimants on a land which is 129 lakh acres, huge area. This huge area is not one piece of land. It is scattered all over forest, inside, everywhere in patches. And that is going to create problems of management of forest. That is going to create problem of animal and human conflict more and more as we go ahead. Rehabilitation rights, they have also not been addressed that well, although they were very good in terms of the provision. Then recognition of 13 types of forest rights are supposed to be done under this act. But the act, as we have already pointed out, it concentrates on one particular type of forest right, and that is the cultivation and habitation. Cultivation also has to be self-cultivation. That aspect is also ignored in most of the areas. Self-cultivation basically again wanted that the people who will be beneficiaries under the act would be the poorest of the poor. But by not adhering to that, we are, and also we know that the relatively better people are always more vocal. They have reached to the higher ups and powers that be. And so they are getting more and more benefit of this act rather than the real ones who were supposed to get the benefits. The reason is not just a slipshod implementation, but also the amendments done by the Ministry of Tribal Affairs and also the guidelines issued from time to time. Another good thing was that the admissibility of us had to be examined very, very critically and carefully. But as was rightly pointed out, because of maybe lack of capacity building of all levels, in fact, we find that in Maharashtra, there was a study done by the Forest Department of 35,044 cases, which were given as final rights. You'll be surprised to find that 2,400 and odd claims which were allowed had roads, nalas, streams passing through the plot. More than 3,000 cases were uncultivated as on the D date, that was the 13th of December 2005, which is supposed to be the cutoff point on which date the cultivation signs have to be there on that land. But more than 3,000 cases were such which were cultivated later on, and they were actually not genuine. About 1,500 cases were given where more than 4 hectares of land was given to the beneficiaries, whereas the limit is 4 hectares. The Terry, Delhi, they also have studied this situation, and they have said that more than 5 lakh tons of carbon dioxide has been released because of the illegally cleared area of 1748 hectares of the study area. So you see, the act was good, initial rules were good, but with tinkering of rules and new guidelines and a slipshod implementation, we have made it a difficult situation, not only for the forest dwellers, but all the citizens of this country. Then empowering FDST and OTFD communities and Gram Sabhas for protection of forests. Obviously, as I said, hardly any work has been done. Another point is that the claimants cannot be evicted unless the process of recognition of forest rights is finalized. That is the rule. But taking its benefit, the influential people are doing fresh encroachments overnight in many of the areas. They will make an application to the Forest Right Committee and show it to the Forest Department and say that unless this process of recognition is finalized, you can't touch me. And there are a large number of such cases which has happened on the forest land because of this particular provision itself. Satellite image is one of the evidences mentioned in the Rule 13 of the rules. But in 2012, the Ministry of Tribal Affairs, it said that the satellite imagery and other uses of technology may supplement other forms of evidence and shall not be treated as a replacement. So the evidentiary value of satellite image being used for whether a particular claim is correct or not has been diluted by this amendment. But as a contrast, as was rightly pointed out by Dr. Pandey, the statement of an elderly person of the village about any of the requirements is taken as a solid evidence. So the objectivity is also gradually getting lost so far as decision of various cases is concerned. The, as I said, the title of most of the cases do not mention the extent and nature both, which means that even if there is a piece of paper in the hands of that tribal or the other traditional forest dweller, after 10 years when he goes to ask for the right that he is entitled to, he doesn't know how much he has to ask for, and the manager of that land doesn't know how much to produce so that that right can be met. This is the situation. There's a lot that needs to be worked on. Another major issue is the verification of existence of cultivation in the past. On 13 December 2005, he had to be cultivating. Now today we have to find out. And if you don't allow the satellite image to come in as an evidence, then only statements of the people are there who can say that yes, this was the cultivation that time. And that creates a lot of problem. Involvement of informed stakeholders at multiple levels are not happening. Capacity building, regular capacity building. In fact, people get transferred. And so regular capacity building exercise has to be there. And one basic question is the alternative to decision making by majority, which can overrule decision that should have been on merits, is a big question in this democratized system of finalization of forest rights claims. So with this, I must say that the Act did come up with a very good intention, but while implementing, we have really, if I can use a stronger word, we failed. And that is what is very disturbing. My suggestions would be,
excuse me, Dr. Jack, can we go for the next round? Your suggestions we can take because
sure.
the paucity of the time.
So
Thank you very much. Thank you very much, Dr. Jha.
From me, thank you so much. Thank you so much.
Thank you, Dr. Jha, for giving. And Dr. Jha has raised a very, very pertinent point. He says, first thing is one should understand the basic concept of this law was that no one is going to be the owner of any piece of land. Only the rights for the collection of the produce is to be given, that to a maximum limit of 4 hectares. But people consider that it is like getting the rights on the land. Land always belongs to the forest department or for the forest, not through any individual. Correct, Dr. Jha, if I have understood correctly? Is it correct?
It's a public land. It's a public land.
It's a public land for the forest only, and it can be only given for the collection of those produce only to those who have a right to stay, who are there, the dwellers, the tribals, or not to any other thing. And he says that the law was enacted with with a very good motive, but the implementation was very bad. It's failed to give what for the law was enacted. And after the law was enacted, it was diluted with the amendments, with the guidelines, and which has created lots of not only confusion, rather it has failed. I will use the word that it failed the purpose, the basic purpose of the law for which it was enacted. Thank you very much, Dr. Jha, for giving your frank views about this Forest Rights Act. Now I would like to invite my next guest, and he is Mr. Kishore Raite. Mr. Kishore is the former member, National Board for Wildlife. He is a renowned conservation practitioner at Mumbai. He has done his postgraduate diploma in international wildlife conservation practices from University of Oxford. He has been working as a conservation practitioner for more than 30 years in central India. His work with the local communities, academicians, field biologists, media, politicians, and administrators for conservation of Satpura landscapes is well recognized at national and international forums. He has served on many policy-making bodies, including the National Board for Wildlife, NBWL, Maharashtra State Board for Wildlife, and Maharashtra State Biodiversity Board, etc. Welcome, Mr. Kishore, on our show. Mr. Kishore, you have already heard what Mr. Pandey, Dr. Srivastav, and Dr. Jha has spoken. And they are very clear in their views that the law was enacted with a very good motive, but it failed because of the poor implementation, or because the law was diluted through the amendment in 2012, as well as the guidelines issued time to time. Now, you being the practitioner, conservation practitioner, and you are dealing with the wildlife as well as the national wildlife also, we would like to know from you the Forest Rights Acts, BANE or BOON? Mr. Kishore, write it, please.
Thank you, Mr. Goel, for giving me opportunity to express my views. And thank you, my colleague panelist, for elaborating this aspect and several dimensions of this subject. I have some restrictions because I am one of the petitioners highlighting several flaws of this Forest Rights Act. So keeping in mind the legal battle in the Honorable Supreme Court, I would restrict myself to very few arguments or the points. Let me first of all highlight and go to the root of this particular act, where from it has come. Let me tell you that I was 35 years old when I filed this petition, and today I'm 48. As a student, I started working for protecting forest at the age of 18 years old. And I have seen massive encroachments mainly done for agriculture purpose, because our country's population is growing and land holding is still same. If you go to any village, you will find that the population has increased, number of households have increased, and agriculture land is same. So there is tremendous pressure of getting more and more agriculture land. And that's why there were massive encroachments I have observed in the entire Satpura landscape in central India. And I started Save Satpura March in 1996. So that's my background, how I am attached with this particular subject. And I had highlighted these agriculture encroachments in way back 1996, not in 2006 when this act came in. And when this act or the draft of this act was tabled before the Lok Sabha and then later on Rajya Sabha, I read the draft, and in the draft it was very much clearly mentioned that this is for removing historic injustice of the tribals. First, let's understand, this was mainly for removing the historic injustice of tribals, not the non-tribals. Okay. Number two, the cutoff date mentioned was 1980, because Forest Conservation Act came on in 1980. And people felt that in 1980, central government took all the powers and state government, there were no powers left with the state governments to deviate forest land for non-forestry purpose, or even to any person who is actually holding the forest land and doing agriculture. So I have several letters which were sent even before 1980 to the state governments, and state governments were very well regularizing those encroachments, agriculture encroachments, in the name of the tribals. Then after 1980 also, I have many letters which were issued by the Ministry of Environment and Forest to the state governments, that if you have some genuine encroacher who is already tilling on the forest land and doing agriculture, please send that information and give that patta to the particular owner. So there were attempts by the Ministry of Environment and Forest to grant the pattas to even pattas. I am not saying rights, forest rights, which Mr. Dr. A.K. Jha has rightly said. So pattas. So that process was very much open in the country, and it has been done. But still people felt, and people always argue that in some remote area, tribals are very illiterate and they don't know anything, they don't understand your language, etc. And that's why they never claimed about their rights over the piece of forest land. And that's why now let's give them the opportunity. So the cutoff date was planned 1980. So if such kind of genuine encroachers are still there, let's just give them the rights over that piece of land. Okay. Now, when this act came in the Lok Sabha and Rajya Sabha for discussion, all the member of parliaments, they said that why only 1980? If somebody has encroached upon the land today, just give it, because this forest land is for free. So this country has passed this legislation, and that's why this cutoff date is that discussion was the discussion was concluded on 13th December 2005, and that's why this cutoff date. So I am not going into the past. I am saying that if this country has passed this legislation and this cutoff date is decided that 13th December 2005, let's be very honest in saying that if now any further encroachment is taking place on the forest land, let's take it very seriously and let's stop it, because this is not the loss of that only village. It's a loss of the country, because we are living in an era where every tree matters. And here you are just losing the forest area at the size of Assam state. We have already lost. And you see the forest state of India reports, and it's not based upon any questionnaire survey. It's based upon digital satellite imagery. And that shows that this country has lost the forest cover. And where are these losses? The forest cover losses have been recorded in the very dense forest area, in the medium dense forest area, and in the tribal districts of this country. So let's understand and let's not argue on this. If there is a forest loss, let's be united in saying and admitting the fact that yes, there is a forest loss and there are massive agricultural encroachments, and then find out the reasons. If this act and provisions of this act have becoming the reasons for growing encroachments, let's also admit and stop them, because this is in the country's interest. We cannot survive without water. We cannot, and water cannot be given by any district collector. Water will be only available if we conserve country's forest area. So let's not play politics. Now this country has seen that people are very much used to in drawing political mileages from any issue. And I have seen that they have considered this particular Forest Right Act also for this. So what I said that this act was only confined for removing the injustice on the tribals, and that's why initially people call it Tribal Right Act. Now it is no more Tribal Right Act. It is OTFD. They are more in encroachments. So let's now in last 13 years, because how long it takes to remove the historic injustice? 1 year, 2 year, 3 year, 4 year, 13 years have been passed, and we are losing our forest cover. So it's a serious concern. And this is not a land distribution act. If somebody has already encroached upon the forest land, if they have the rights over the forest area, then there is a set procedure of granting the claims or rejecting the claims. Now, I am not talking about whatever claims have been granted, because the states have granted 18 lakhs titles. Now, Dr. Jha has said that it is around 19 lakh titles over the 19 lakh forest land. So it's a huge, and over 72 lakh hectare of forest land. So it's a huge chunk. Now, I'm not arguing on whatever has been accepted by the states, because it was accepted through a 3-tier committees, the village level committee, SDLC, and the district level committees. Now I am talking about if the claim has gone through all these 3-layer committees and it is finally rejected by the DLC, the district level committee, are you going to accept it or not? If it is accepted, granted, then you are accepting. But if it is rejected, then you are arguing that all the 3 committees have played the game and that's why there is a rejection. And you are not ready to accept digital satellite imagery. So you are ready to accept if a person is saying that, yes, the gentleman is staying here in this village since last 3 generations, then you are believing. But if digital satellite imagery is saying that, no, in 2005 it was a forest, in 2006 it was forest, in 2008 it was forest, and now it is no more, you have to accept it. So you cannot be selective in saying that if the claim is granted, we accept. If the claim is rejected, we don't accept. This is not acceptable. Now let's understand one more thing. Whatever claims have been rejected, now I am only talking about rejected claims, not about the accepted claims, because whatever has been accepted, they are accepted and Honorable Supreme Court would pass an appropriate order. Regarding rejected claims, they have been rejected by these 3 committees, and most of them, you listen, most of them, I will tell you this rejection, most of them have been rejected by the Gram Sabhas at the village level. Now, when this entire country has come to the stage where they are saying that Gram Sabha is the supermost body in the country, and Gram Sabhas are rejecting these claims. Why? Because people know who are the outsiders and who are the people who are staying in the village. And that's one reason why Gram Sabhas are, the rejection at the Gram Sabha level is more. It is not rejected at the SDLC and the DLC. And even in SDLC and DLC, let me point out the fact that though we are talking about forest lands, forest department's role is very less. Okay, revenue department and tribal department, even implementation responsibility has been given to the tribal department, not to the forest department. And you are talking about distribution of forest land. So that's something which is very serious, and that's why all these issues have been come up and we are losing this forest cover. So I am talking about the rejected claims. If so many, means over 14 lakhs claims have been rejected, let's now give them back to the forest department and restore these lands, because it is in the interest of the nation, it is in the interest of the world. But this is not happening. What is happening? Politicians are sending letters to the forest department and the revenue department to reconsider these claims. That means they want to make this act open-ended. How long you are going to reconsider? If the claim is already rejected by the DLC and there was no provision of appeal in this act, now the Maharashtra government has constituted the committees at the divisional level to hear the appeals, whereas this act doesn't provide any provision of appeal. Okay, so this has happened in Maharashtra, and rest of the states also want to hear the appeal. And even I am damn sure, means there are several letters from the Office of Governors and other offices saying that you reconsider, but reconsider till when? Till you accept the claim, which is already rejected by your own mechanism. So that's something which is very bad. You take the Orissa example. Around 20,077 claims were filed as scheduled tribes. They had mentioned that we are scheduled tribes and they had filed the claim. Out of them, 13,851 claims were rejected just on the ground that they were not a scheduled tribe. That means these are the fake claims. The Orissa state government has filed this affidavit and stated this. I am not saying this. So if you just see the situation which is stated by the state governments in the Supreme Court, Honorable Supreme Court, these facts are really proving that the provisions of this act are badly implemented, and these are implemented towards destruction of the forest areas. And this is very bad for this country.
Okay, okay.
One more point.
Okay, please be brief.
I would just mention, you cannot be selective in the implementation the provisions of this act. This act do not talk only about individual rights and community rights. It also talks about the wildlife rights in the protected areas, sanctuaries and national parks. Now the central government has withdrawn guidelines issued to declare critical wildlife habitat in protected areas twice. And in last 13 years, not a single protected area, sanctuary or national park has been declared as critical wildlife habitat. Whereas in the same protected area, you have granted individual forest rights and community forest rights. So what does it mean? You are denying rights of wildlife in the protected area, which are meant for wildlife. And you are continuously granting for last 13 years, IFR and CFR in the protected area. So you cannot be selective. So I am totally, I am not happy with the way this country is losing forest and forest resources. Thank you.
Thank you very much, Mr. Kishore. And Mr. Kishore was given his anguish today, although he mentioned very clearly in the very beginning that he is one of the petitioners in the Honorable Supreme Court. So he would not like to discuss the legality, but he has mentioned what is the reason, what is happening. He says whatsoever the act has been formed, it has been implemented very badly, and that's why the more and more claims, although they were rejected even by the Gram Panchayats, but still the state governments, either due for some influence or for granting for those non-genuine persons, they are allowing the appeals, and that's why the condition is very bad, and he says he's not at all happy. Thank you very much, Mr. Kishore. Now my question goes to Mr. Pandey. Mr. Pandey, you have heard the views of all the panelists, including yourself. Although you all have used very flowery language, I do not want to use that. I can very bluntly say this is nothing but corruption of a very, very large scale, right from the Gram Sabha level to any other level or the top level we can go. Because how come the law which was formed for the beneficiary, and the beneficiary were those who poorest of the poor, it has been used by the rich people by everyone. So what you say, because implementation of a law cannot be done by two reasons. One reason is that the law is such which is not possible, it's not practical. And the second reason is there is something ulterior motive is involved. And the way all the panelists have spoken, it shows that is the ulterior motive. After all, we have so much good infrastructure. We have IFS officers, class 1 officers sitting in the forest department. How come these things are happening until unless there is some corruption is not there? Mr. Pandey, please unmute yourself. Please unmute.
Well, Mr. Goel, you will recall I had mentioned when
your voice is audio is very weak, Mr. Pandey.
If you recall, when I was making my presentation,
I
had mentioned that whatever had been provided under the law, the extraneous factors have had a major role to play in the implementation of the act. I have already mentioned that. Now, what all other members of the panel have also accepted that yes, the law, its words and spirit have not been followed at all. The empowerment of the committee members and the exposure has been wanting at all levels. Now, it has to be accepted and admitted what Mr. Rite has mentioned, that when there is no provision for appeal, how can you keep on having an appeal? The cases which have been rejected once for all have been rejected once for all. There cannot be there cannot be any scope for appeal in that. But keep on appealing till the time you finally make the committee to accept it, the claim. I think it is going stretching too far, and it is not stretching too far for us, too far for future generations also. We may
Okay.
not have wildlife. Now, I mean, if we have to do something, it is a welfare measure. It is not a land distribution measure. It is a welfare measure, and it should have been implemented with that aspect in mind, that it is limited only to people who were there on that appointed day. It cannot be an ongoing process of encroachment and regularization.
Okay.
Thank you.
Thank you, Mr. Pandey. You have made a point, because everybody knows the poorest of poor or a poor person cannot go for appeal again and again. Everybody knows very clearly what is the reason. So it clearly shows that the corruption is in this. That is the reason the implementation is not taking place. Now, my question goes to Dr. Srivastava. Dr. Srivastava, when this act was formed, one of the reason was to curb the Naxalism, and you were at Jharkhand, which is also having the Naxalism. Do you think Forest Rights Act failed to curb Naxalism? Please unmute yourself, Dr. Srivastava. Please, yeah.
Yeah. Let me say that Naxalism and the Forest Rights Act, the basic premise that you mentioned just now, I personally disagree. Because deprivation of any kind of social rights or my rights or any kind of thing comes where the Naxalism you have talked about, and forest even so assign this as one of the reasons for the Forest Right Acts for implementation or issuance. I beg to disagree. One, two. Uh, I agreeing with what Dr. Pandey has said. I'll like to say that the rights and the spirit of the FRA is to be appreciated. At the top level, Gram Sabha understands its full well. But at the different level that we have created, that these hierarchies have to appreciate it. Third and most important is integration of these various acts that are operating in the same area, be it the MOEF related act or the PESA or the FRA, because all of these things have emerged from the parliamentary system of ourselves. They talk about good of the people and the good of the resources as well. We have our NDCs for the climate change, national NDCs commitments we have to fulfill. And if we are amongst our different sectors, if we are having our conflicting views and contradictory ideas, then probably we are going to miss the bus. Let's resolve this issue and at least we should appreciate that some conflict exists and we have to resolve that. Thank you.
Okay, thank you, Dr. Srivastava. My question to Dr. Jha is, Dr. Jha, you mentioned about 2012 amendment. Now, it clearly shows this amendment was to increase the beneficiaries, to benefit the more number of beneficiaries, and definitely those more number of beneficiaries are not the genuine one. So do you think it was done by using some, everybody knows because why it was done and amendment was taking place, although definitely by the parliament, because if it was amendment on the act. So do you agree that this was done intentionally to give the benefit to certain persons or organizations in 2012?
See, you already said that there were many protests, etc., with reference to this act. During implementation, also you might have seen that there were a number of processions, and who were in those processions? Who is the person who can reach the Mantralaya today? We started satellite imaging because we wanted to help the most poor guy who had no proof at all, but he was tilling somewhere inside the forest area. He had no papers with him, no evidence. There was nobody who would write for him that, yes, he has been doing this for ages. Because he's such a poor man. He has nothing to give to anyone. Satellite image was to give that person the benefit because it was objectively seeing everything. The evidentiary value of satellite image was reduced, one. Number two, the definition of OTFDs or FDSTs, that was relaxed. All this, I mean, you know, when we were implementing, there were some NGOs who were against the forest department officer holding the GPS instrument also. They said, oh, GPS, why in the forester's hands? We trained 1 lakh persons in GPS handling, including the foresters, other department people, even the villagers, and also the NGOs. We said, okay, you hold it. It doesn't listen to any person. It listens to the satellite. So that is how interests they come up, and those who have reached, they finally make the changes happen. I'll just take another 1 minute.
Please be brief because
minute.
I have only 1 minute left for Mr.
Okay.
Kishore.
Okay.
Thank you very much, Dr. Jha.
Thank you.
Mr. Kishore, you have mentioned and you know the legality, and you said that you mentioned that this act was, when it was formed, for the benefit of the the forest dwellers or the poorest of the poor. Everybody agreed. Same thing. Today, the government is saying this Farmers Act are for the benefit of the farmers. Now, do you agree that the fate of this Farmers Act is going to be the same for the benefit of the corporates, like what we are seeing today with the your Forest Act? Because government is saying that it is, I am sure that in 2006, government have mentioned this thing, that's for the benefit of the poorest and poor, the forest dwellers, etc., not for the big wigs. I know personally many big names who have encroached the forest lands. Nothing is happening. No one is taking interest, whether it's a forest department, because everybody knows that somebody from the top will give a call and no one have dared to say anything. What you say about this? Very little time to you.
Yeah. Mr. Goel, being from the farmers family, I would definitely support the agitation of farmers, what they are saying. And the discussion really should be on the provisions of the Farmers Act, whatever legislations they have brought right now. I won't go into details of the farmers legislation, but as far as the Forest Right Act is concerned, whatever provisions have been made, and if, means we have to be very open in thinking, if passed, for 13 years have been already passed in implementation of this act. And if it has, it had to remove the historic injustice, it has already removed it. I strongly believe in this. If there were any genuine cases, they have been already addressed. Now, we have come down to the stage where we have to put the full stop on its implementation. And let's protect our forest. And whatever claims have been rejected, let's restore them back to the forest. That's it.
Okay. Thank you very much. So today you have seen that how our forests have been exploited, encroached by the big wigs, and the genuine rights of those forest dwellers, the poorest of poor, are being denied. This is the empathy. This is the condition of the country. We must protect our forest, because this is not for us, as one of the panelists says, this is for the future generation. If the forest will not be there, what is going to happen? Thank you very much. And today's program, which has been live telecasted by V4 News, Global TV, V4 Stream, Malnadu TV, Newsgaon se Samvad Sarocar News, as well as was shown live on Facebook and YouTube. And our endeavor is to bring to you every day a new topic. And tomorrow, media conference with Lal Goel. The topic is 2020, a challenging year for working women. And our panelists are Dr. Rajiv Anand, Senior Psychiatrist, Mumbai, Miss Preeti Manucha, Army Public School, Ayodhya, Faizabad, Miss Neeta Tandon, Nimla Convent Inter College, Lucknow, Miss Priyanka Kharbanda, Marketing Manager, Jubilant Food Works Limited, New Delhi, Advocate Rashi Gupta, Faculty of Law, guest, Delhi University, New Delhi. So please tune in tomorrow for media conference with Lal Goel at 10:30.